We've got the attendees coming in thick and fast. We're going to wait for numbers to go up and steady, so we're making sure everyone's logged in and watching before we go. And then we'll get cracking. For those of you who are logged in as things stand and are watching, my name's Marcus. I'm a member of the Clinical Negligence and Personal Injury team at St John's Chambers. Hopefully you've also got on screen Rob Mills, who's also a member of the Clinical Negligence team. We are, as I say, just waiting for Zoom to allow attendees in, and then we'll get going. So if you bear with us a couple of moments, we'll just wait for everyone to come in. All right, I think numbers have steadied off. All right, well, look, we've just turned 1 o'clock, so we'll get going. As I said, for those of you who have joined in the last few seconds, my name's Marcus, member of the Clinical Negligence team at St John's Chambers. You should also have on screen Rob Mills. We are here today on a fairly glum-looking Tuesday where I am. I don't know if it's the same where all of you are based, looking out of either the office window if you are sneakily working from the office or from your own homes, wherever you set up camp, in dining rooms, bedrooms, self-made offices. As you can see behind me, we've hit December, so on a glum-looking Thursday, I've tried to brighten up with a bit of Christmas tree lights and baubles to get in the festive spirit in the countdown to Christmas, and hopefully we can give you an hour or so, just under an hour, of interesting and recent clinical negligence topics arising from recent decisions in the last year or so. As far as the structure is concerned, the topics we're going to cover are, firstly, Rob's going to give you a hot off the press rundown of the decision of XM from the last couple of days. Then he's going to cover a recent case which deals with the tests from Bolam and Belido. And then in terms of causation, I'm going to touch upon a case that deals with and grapples with the application of the but-for test and material contribution. And then towards the end of the session, Rob will talk to you about anonymity orders, and I'll touch upon covert recording of medical legal examinations. Hopefully we'll be able to cover all of that within the hour. There is a Q&A function for those of you who are probably very familiar with Q&A on Zoom now. There is a Q&A function which we are more than happy for you to use. We'll probably take all questions at the end, so if you type them in there as we go through, Rob and I'll do our best to pick up as many of them as possible once we hit the end of the session. So without further ado, with the festive lights behind us, I'll hand over to Rob to get cracking and get stuck into the first couple of cases.
Thanks, Marcus. That's great. Good afternoon, everyone. I hope you find today a useful, interesting session. The first case I wanted to touch upon is one which is not on your slides. The reason is that it's only just come through on my law tales and came out about a week ago. It's the case of XM and Leicestershire Partnership NHS Trust, if you want to look it up. It's an interesting case because it considers, in effect, the liability of health visitors in the context of when they come to someone's home to examine their babies in the period after birth, and the extent to which they may be held liable for something which is missed or negligently recorded in those appointments. They've often been a bit of a grey area, health visitors, in terms of liability, because obviously a lot of the time they don't have the in-depth medical knowledge that, for example, a GP or other doctor might have, but clearly their role is still very important. They're the only professional examining that baby in its first weeks, and they need to be able to pick up on red flags. So it's an interesting decision looking at that in the High Court. I'll just give you a brief summary of it. In essence, the baby suffered sadly from a rare and benign brain tumour, which caused the overproduction of cerebrospinal fluid. That fluid accumulated in the brain, making it swell and making the head grow abnormally fast. And in summary, at the various appointments where the health visitor came to assess the baby, including measuring its head, the head was larger than one would expect, and indeed accelerated in the size of its growth. But the health visitor did not pick up on, to the extent that she should, the red flags in terms of growth that was happening. And what the court held was, in terms of the standard of care, was that the Trust's standard operating procedure required health visitors to take a child's weight and head circumference and plot them on the centile chart in the personal health record of the child 10 to 14 days after birth, and thereby set a baseline against which future growth could be measured. Weight and head circumference were again to be measured at the 6-week assessment, and that 6-week assessment could be conducted either by a GP or a health visitor. This is the important point. Whoever undertook that assessment was responsible for interpreting the head circumference measurements and considering whether growth was along the expected centile lines. And the same standard of care applied, regardless of whether it was a GP or a health visitor. They had to take, record, and interpret the measurements to the standard of the competent healthcare professional charged with performing those tasks. So the actual profession, as it were, was irrelevant. It was the task which they were performing. A little bit similar, you might think, to when considering assessments or treatment in hospital that might be undertaken by doctors of different seniorities. Ultimately, it's the standard of care for the procedure being undertaken which is applied, and claiming a junior position will often not get you off the hook. Similar messages here. And the court found that while health visitors were not required to make diagnoses, they had to follow the standard operating procedure and competently interpret the measurements in accordance with the published guidance. And there was particular guidance which the court went through, and that health visitor had not done so. That's it in a nutshell. There was also a consideration of breach by a nursery care professional, so somebody was a nursery nurse in effect, and breach was also alleged against them. It was found that they weren't in breach of duty by failing to appreciate, just by sight as it were, that the baby's head was disproportionately large. The standard of care expected of a nursery nurse was different from that expected of a health visitor. Although they perform certain delegated health visitor tasks, the nursery nurses aren't qualified nurses. They're not trained to take or interpret head circumference measurements, and they wouldn't be looking at the charts. So not as much of a burden placed on the professional in that context, but the health visitor, yes, and really to the equivalent of a GP if they'd been undertaking the assessment. So it was judgment for the claimants in that one, and an interesting one for anybody who undertakes work of this nature in the neonatal period. I'm just going to start my slideshow. Before we move on to the cases to discuss today, I also just wanted to highlight or signpost you to another talk which deals with the case of Paul and Royal Wolverhampton NHS Trust. Many of you may have come across this. It's the secondary victims application, quite an important result, which really seeks to provide some clarity as to the proximity criteria for secondary victim claims, and whether there needs to be proximity between the negligence or breach of duty on the part of a defendant and the shock experienced by the claimant. Is something which defendants had with some success and been striking out secondary victim claims as there wasn't the proximity between breach and shock. However, the court in Paul in effect found that wasn't required, and it's about proximity between the actual damage being sustained and the shock on the part of the claimant. So if you've got that, then that in effect is what is required. I've just seen that the slideshow is going a little nuts, so I'm just going to try and regain control of that. There we are. Yeah, I've done a separate talk on Paul, which you can find on our website, and feel free to ask me any questions at the end of this talk on Paul, because it's an area of interest of mine, or do go and watch that talk, and I hope you find it useful. But we won't be going through it in this talk, so I don't want to repeat content for those who've already seen it. What I want to move to first is the Bradfield K and Coke case. Recent case, as Marcus has outlined, concerns in effect the Bolam and Bolitho test, something which the courts wrestle with on a not infrequent basis, And this is a good judgment from my point of view. It's a really encouraging judgment of a court applying these cases in the right way and reaching a reasoned conclusion. Let me summarise the facts first. It's one where it pays to go a little bit into the technicalities of the expert evidence so that we can fully understand how those main cases have been applied to the expert evidence. So it's a case that concerned really whether a defendant who was a consultant orthopaedic surgeon was negligent in the performance of a total left hip replacement in 2009, and also a follow-up consultation in 2010, although we're really looking at the actual surgery for the interesting analysis. Claimant didn't recover well from that hip replacement, got severe pain in the thigh and groin immediately after the operation. He allegedly reported these symptoms during the appointment in 2010. No investigations were undertaken. In 2011, claimant seen again. There's still pain and a clicking, and the defendant thinks it's likely due to correctly thinks that it's likely due to the psoas tendon catching over the anterior lip of the acetabular cup. And then in 2012, a different surgeon performs a revision surgery, notes in the operation note that the anterior of the cup was prominent and was catching on the anterior structures. So the suspicion had been correct as to the problem. This revision improved but didn't resolve the pain, and a further revision surgery was undertaken in 2016. So quite a lot of unnecessary surgery for this claimant. What were the allegations? Well, the claimant said, and this is the important one for our analysis, when the defendant performed the total left hip replacement, he permitted the acetabular component of the prosthetic hip to be prominent in such a position that the iliopsoas tendon caught on it, causing him to develop iliopsoas tendinitis. In other words, it was negligently performed, negligently positioned, and that's what led to this pain and suffering in the revision procedures. There were two other allegations about using the wrong component and not, as I say, acting properly when he followed him up at the review appointment. We're only really concerned with A, and that's what I want to focus on, because that's where the Bowen-Bolitho analysis takes place. So expert evidence, both parties, as you'd expect, gave expert evidence. We had Mr. Chatterjee for the claimant, Mr. Manktalo for the defendant. The former, Mr. Chatterjee's practice was mainly knees. So it is a classic example of an orthopaedic surgeon, so technically the correct field, but his experience with this particular surgery was relatively limited. The defendant's expert was mainly and primarily focused on revision hip arthroplasties, so he really was the ideal expert, one might think, to be commenting. He had a lot of experience with this kind of surgery. And the judge was clear, Mr. Manktalo appeared to be better able to comment on the practice of hip specialists as a whole in the UK than Mr. Chatterjee. So thinking of the Bolam test, what different bodies of the profession might do, Mr. Manktalo would appear to be very well placed to comment upon that. So you might think, certainly going into it, that the defendant had something of an advantage in terms of the expert evidence. Now, the main aspects, as I say, concern the placement of the acetabular component, and there were various points on which the experts could agree. And it's worth going through those in a little detail, again, because they very much inform the judge's reasoning. So the first is that if the acetabular component is placed so that it catches on the iliopsoas tendon as it passes over the exposed rim of the cup, the tendon can become irritated, inflamed, and painful. So they accept the mechanism. Claimant developed that tendinitis in the region of the hip joint. It's a recognised complication of total hip replacement surgery. It can occur for reasons other than the orientation of that component. In the present case, though, that was the most likely reason for the pain that was experienced, particularly given the findings at the revision surgery. Fourth point, the protrusion of that component beyond the anterior margin of the acetabula was influenced by anatomical variation, first, degree of anteversion, second, and the depth to which the socket was implanted. Now, the focus in this case was on the degree of anteversion of the implant and any anatomical variation. There wasn't any disagreement about the depth of the socket. There was obviously a range of, depending on your patient, a range of variations in terms of the placement of that component. It can be a challenge, and the ideal position will vary from person to person, generally 15 to 25 degrees, but there's an acceptable range, 10 to 30 degrees. Number 8 is that surgeons should ensure that that component isn't placed in a position that could interfere with the iliopsoas tendon, such as beyond the acetabular margin of the native acetabulum. 9, there was no surgical or anatomical reason in this case to leave the cup prominent. In other words, it wasn't done intentionally or for any good reason. And finally, it was a straightforward position to remove the cup and reorientate it if intraoperatively it was found to be prominent. So in other words, the cup was placed here in the wrong position. It didn't need to have been placed in the wrong position, and it could have been corrected intraoperatively. So quite a lot of points agreed there, which you might think favour the claimant in terms of the expert's analysis. So what were the issues of dispute? Well, Mr. Chatterjee said for the claimant, easy to check for prominence by running a finger or instrument around the acetabular rim. So in other words, he's saying, yes, you can easily check for this. So by inference, there's no excuse for leaving it that way. He wasn't able to point to any particular textbook or handout or other authority to demonstrate that that was the standard throughout the profession at the material time in 2009. But he maintained that leaving the component proud like that, where there wasn't any anatomical peculiarity or surgical necessity, was a breach of duty, more or less for the reasons that we've set out in the agreed points. And Mr. Mountellow's evidence for the defendant, this is where it's interesting, really. He did many hip revision surgeries, and he would say surgeons will run a finger or instrument over the socket to check for prominence. But in his revision practice, he saw prominent acetabular components quite frequently. In other words, this is something which happens not in an out of the ordinary scenario. And he said a number of surgeons made this error. Pay attention to the word error. He accepts it's not something that should happen, that needs to happen. It's a mistake in effect, but it's quite a common one. And the judge derived from that evidence that some surgeons did allow the acetabular components to stand prominent from the native bone, and that Mr. Mounttellow was critical of this conduct. In other words, it wasn't good practice, but there's certainly a body of the profession that does it. The defendant say in evidence that the surgeon who performed this index surgery was that he had not been taught at all to check for prominence, and so he didn't do so. And the judge accepted that was the case. Mr. Mounttellow, what he said was, while he's critical of the prominence of that component, he didn't consider it to be a breach of duty in the legal sense, for the simple reason that there were surgeons who did likewise, although he gave no particular justification for why it was not a breach of duty. You might think he was straying a little too far into legal analysis himself in assessing what was and was not a breach of duty, but nevertheless, that was how the evidence was presented. The judge was clear that there was a body of surgeons, including both the experts in this case, who thought that surgeons performing this procedure should ensure that that component wasn't prominent. But there was also a body that did not subscribe to that opinion, which included the defendant, who said he wasn't even trained to do it. So the defendant's counsel said, clear Bolam defence, because there's a body of profession who doesn't do this. And the claimant therefore must rely on belief, though, if they're going to succeed at all. We'll come to the distinction between the two in a moment. Right, now in fact, we look at the judgment, and I start off by citing the main passages from Bolam and Belitho, which were in the judgment, so we have an understanding of the interaction. The starting point is the well-known jury direction in Bolam, where the judge said, I myself would prefer to put it this way, that he's not guilty of negligence if he has acted in accordance with the practice accepted as proper by a reasonable body of medical men skilled in that particular art. Putting it the other way around, the man is not negligent if he's acting in accordance with such practice, merely because there's a body of the opinion who would take a contrary view. That was expanded upon in Belitho, where the judge said, in my view, the court is not bound to hold that a defendant doctor escapes liability for negligent treatment or diagnosis just because he leads evidence from a number of medical experts who are genuinely of the opinion that the defendant's treatment or diagnosis accorded with sound medical practice. In Bolam, Mayor James Justice McNair stated the defendant had to have acted in accordance with the practice accepted as proper by a responsible body of medical men, and later in the judgment referred to a standard of practice recognised as proper by a competent, reasonable body of opinion. Judge Belitho went on to say, in another case that he cited, Maynard's case, an older case in 1984, Lord Scarman referred to a respectable body of professional opinion, and the use of all these adjectives in the case law, responsible, reasonable, respectable, all show that the court has to be satisfied that the exponents of the body of opinion relied upon can demonstrate that such opinion has a logical basis. In particular, in cases involving, as they often do, the weighing of risks against benefits, the judge, before accepting a body of opinion as being responsible, reasonable, or respectable, will need to be satisfied that in forming their views, the experts have directed their minds to the question of comparative risks and benefits and have reached a defensible conclusion in the matter. So, in the judgment in this case, the court relied upon the evidence of the surgeon who performed the revision procedure, found that the cup was not placed within the confines of the native acetabulum, was not placed at an appropriate degree of anteversion, and that caused the component to be prominent, which led to the irritation, pain and suffering, and revision surgeries. It was held that that surgeon, Mr. Cope, did not ensure that the acetabular component was not placed in a position that could interfere with the iliopsoas tendon because he hadn't been trained to do that. And based on the defendant's expert witness, the court found as a fact that some surgeons undertaking arthroplasties do allow this component to stand prominent from the bone. The court had evidence that there was a body of surgeons, therefore, undertaking hip replacements who didn't ensure that there was this required smoothness when undertaking it. But what the court didn't do was accept the submission that if there was evidence of professional practice that supported the defendant's practice, i.e. that others did the same, that the claimant would have to rely on belief then. And the judge said, and this was the good passage in my submission, in my view, both Bolam and Bolitho require the court to examine the different schools of thought and to ask itself whether the school of thought relied upon by the defendant can demonstrate that its exponent's opinion has a logical basis. So it's concluded that there wasn't a logical basis for ensuring, or for neglecting to ensure, that the acetabular component was not placed in a position that could interfere with the iliopsoas tendon. No good reason had been advanced for not taking this precaution. The risk of impingement was a well-recognised risk, could have been easily identified and rectified. There was no surgical reason for running the risk in this particular case. It was concluded that the defendant's expert witness didn't explain why Mr. Cope was not in a breach of duty. The judge noted that that defendant's expert plainly thought that a surgeon ought to avoid prominence of the acetabular component, although he gave evidence that there were surgeons who did not ensure that that component was not prominent, and he clearly disapproved of their views. He didn't offer a justification or rationale for neglecting to ensure that the acetabular component was not prominent. The judge said, I was left with the impression that Mr. Mantelo's justification for asserting that there was no breach of duty was because he said so. And so, unsurprisingly, after that analysis, they found for the claimant. Now, points of analysis that I wanted to go through with you, in essence, just setting out there on that slide the history really of the Bolam test, which from my point of view wasn't ever intended to allow doctors to sanction a practice simply because it was repeated by others in the profession. And I think there was a tendency, certainly in some of the earlier judgments, whereby if an expert could come to court and effectively say that there was a body of the profession that did something, to then think that the Bolam test was satisfied. And really, that placed the medical profession, I'd suggest, on more of a pedestal than it should have been placed on, because ultimately it has to. An opinion such as that, which seeks to say that there is a justifiable, reasonable body of the profession that does something, to withstand logical analysis. And Bolam never intended to assert anything otherwise. But of course, Bolitho came along to support and expand upon that. But I suggest it wasn't really saying anything new. And this judgment is a good example of that. You had an eminent defendant expert, very well qualified in his field, who came along and effectively said, well, I think there's a body of the profession that do this in my experience, so therefore it's not negligent. The court didn't accept that, sided with the claimant who had the less well qualified expert, but ultimately had the better case on logical analysis. And therefore, where there isn't that ability to explain a justification for why a surgeon undertakes surgery in a particular way, if there is not that logical analysis, and indeed it can lead to a poor outcome as it did here, then the claims will succeed. And those last two slides, I've set out a bit of a history, which I won't go through in full because I'm conscious of time, but really how English courts have perhaps at times strayed too far towards reliance on medical evidence, but there's now a helpful trend, which this case shows, of subjecting that legal duty to the logical analysis, which it should be. And hopefully this case can be used going forward to support that analysis from either a claimant or a defendant in running the correct test. And I will now pass to Marcus to chat about the Leach judgment.
Thanks, Rob. I think interesting case, the Bradfield case. For those of you who've had the benefit of seeing Mr. Chatterjee, who was the expert for the claimant in practice, he's quite a forthright expert. So I imagine, and Rob will be able to say one way or another, having seen the judgment in detail, but I imagine he gave quite forthright evidence, and good evidence probably, despite being objectively the less qualified or experienced expert in that particular case. And Rob, I take that as practitioners probably take that as an example of the courts looking to regain control over these cases, as opposed to the medical profession essentially leading which way the court should find. It is.
Yeah, I think that's right. That's right, Marcus. And I think it moves us in a better direction. I think there's a difficulty in the way that it's been trending in clinical negligence, that if one can wheel out an expert who has a certain opinion, and indeed certain experts tend towards either the claimant or defendant end of the spectrum, which in itself is wrong, because of course they should be independent. The more we have scrutiny on this logical analysis and push the medicine to be justified, I think the better for our profession.
Yeah, and counter perhaps to the way the courts have dealt with cases that have grappled with the Belido test in recent years, which has tended to be sort of a result of a last resort by claimants to try and prove their case, and courts have often dealt with it in quite short shrift. So, all right, interesting case. Well, look, this next case is also interesting for entirely different reasons. This is the case of Leach North East Ambulance Service NHS Trust from this year. Essentially, two practical reasons why this case is interesting. The first is it deals with or addresses how to deal with post-traumatic stress disorder and the but-for test and material contribution test. So looking at how both those tests of causation are applied to cases involving PTSD, and also looks at, if you are to apply the material contribution test, is PTSD a psychological disorder, an indivisible or divisible injury, for the purposes of looking whether the loss as a whole should be apportioned between culpable or negligent and non-negligent periods of that loss. So we'll get stuck into it, but those two practical reasons grapples with the two tests of causation, and also whether the loss should be attributed to or apportioned to the culpable period at the end of when you're looking at the assessment of damages and what the defendant ultimately should pay if the claim is successful. So in this case, just wait for the slides to catch up. Factual background is probably important just to recap on briefly. Claimant was a 41-year-old woman. She suffered a subarachnoid hemorrhage, so a bleed on the brain, as a result of a ruptured aneurysm. She called an ambulance at 22 minutes past 2 in the afternoon. Timings are going to be quite precise here, so quite important. Claimant reported in that call that she was suffering from severe headaches, breathlessness, and vomiting. She essentially let it be known to the call handler on behalf of the ambulance trust on that call that she feared she was going to die, and that her condition was deteriorating and she urgently needed an ambulance. And the judge essentially found as a fact that there could be no doubt whatsoever. He said that she was very poorly, whatever the diagnosis ultimately was, and she was in severe distress. Despite that, the ambulance didn't arrive until 11 minutes past 4 that afternoon, so a period of 1 hour and 49 minutes later. Ambulance arrived, took the claimant to hospital, where she thankfully underwent surgery and made a good recovery from the bleed. But as a result, she developed significant PTSD, and that wasn't disputed between any of the experts, and that was the issue that the court had to grapple with. Bit more background before we get stuck into the analysis of causation. Defendant had admitted breach of duty. In other words, they admitted that they'd negligently delayed getting the ambulance there to pick her up. They said, look, we accept that the ambulance should have arrived by 15:40 instead of 11 minutes past 4. So they admitted a 31-minute period of negligent delay. Now, as an aside, the judge said, well, that leaves about 1 hour, 18 minutes of a period that you're all saying is reasonable to get an ambulance there. And said, look, I can't see how that time period can be justified, but if you're all proceeding on the basis that it was only a 31-minute negligent period of delay, then so be it. Perhaps an indication that judges would be persuaded that the sort of time frame involved, 1 hour 18 of reasonable delay, might be too long in these sorts of circumstances, but that's perhaps a matter for a different case, because the parties proceeded on the basis, and the judge proceeded on the basis, that he was only concerned with a period of 1 hour and 18 minutes reasonable delay and a period of 31 minutes culpable delay, so negligent period. And as I said, the key issue here is whether the negligent period, that 31 minutes, that period of delay caused or materially contributed to the onset of the claimant's PTSD. That was ultimately the question the judge was being asked. So just to put that into context, you can see there starting, claimant suffers the subarachnoid hemorrhage at about 2 o'clock, makes the call at 22 minutes past 2. That's when the time starts running, essentially, for the purposes of looking at causation from causation of the PTSD. There's 1 hour and 18 minutes of reasonable delay until 20 to 4, where the ambulance should have arrived. And then that leaves us with that 31-minute period of negligent delay until the ambulance actually did arrive. So the claimant's case was based on the expert of Dr. Smith, who essentially said, look, it's not possible to ascertain when the PTSD was triggered during the period between the first ambulance call, or the call to the ambulance, and being taken to the hospital when the ambulance had arrived. It's just not possible to say when it was triggered. The whole period was pretty traumatic and responsible for the onset of PTSD. So we can't answer the but-for question, and therefore we're into the realms of material contribution. And given that 31 minutes in this context is, give or take, about a third of the entire period that we're talking about, it is certainly, or has certainly contributed materially to the loss, and therefore the claim should succeed on that basis. The defendant's case was twofold in response. They essentially said, on the basis of the evidence of a Dr. Bowers, that the claimant would have developed PTSD anyway by the time we roll to 20 to 4, at which point the negligent period starts. So even if the ambulance had arrived at 3:40, the defendant's case was, in writing before the trial, and that's important to note for a moment, it was that the claimant would have developed PTSD in any event, irrespective of that negligent 31-minute period of delay, so therefore they couldn't get home on the but-for basis. But in the alternative, they said, look, even if the material contribution test applies, the claimant's injury, the losses flowing from the PTSD, should be apportioned between the reasonable and culpable periods of delay. So essentially, you should look at the percentage of the 31-minute period of delay contributed to the overall PTSD and apportion the loss that the defendant was responsible for accordingly. So the court had to grapple with those arguments. And in that context, the court reminded itself of the correct approach to causation in any case, which is set out in Bailey. You will all know this, no doubt. Essentially, can you answer the but-for test affirmatively one way or the other? So if you can show on the balance of probabilities that the injury would have occurred as a result of the non-tortious cause, so the non-negligent event, in any event, then the claimant will fail the but-for test. Alternatively, if you can answer it affirmatively in that the evidence demonstrates that but for the contribution of the tortious cause, so the negligent event, the injury would probably not have occurred, then the claimant will have satisfied the but-for test. So if you can show that without it, the injury wouldn't have occurred, then you get home on but-for. The key part, as we all know in material contribution, is that where medical science doesn't allow you to answer the but-for question affirmatively one way or the other, you simply don't know what would have happened. But you do know that the negligent event had a material contribution or made a material contribution, that's to say, was more than negligible or de minimis in its contribution. Then the but-for test, they said in Bailey, is modified and the claimant will succeed. So the court in this case looked at it, applying that framework to this case and to cases of PTSD. They essentially said, look, if the claimant can show that she would have developed PTSD in any event, irrespective of that 31-minute negligent period of delay, then the claim fails. Equally, if she can show that but for the period, that 31-minute period, she wouldn't have developed PTSD, then the claim succeeds. Fairly straightforward. Judge said, but if on the other hand, the evidence is incapable of supporting either of those two propositions, then if it can be shown that the negligent period, so that 31-minute period, has made a material contribution to the PTSD, then the claim succeeds. So applying that Bailey framework to this case, Judge then went on to answer those questions. And the judge looked at the defendant's case and the defendant's evidence, and importantly, between writing his reports pre-trial and giving his oral evidence at trial, there was a pretty radical shift in Dr. Bowers' evidence. As I said before, his evidence pre-trial in writing was that the claimant would have developed PTSD in any event by the time he got to 20 to 4. He'd said that time isn't a necessary factor for the onset of PTSD. And even when you look at that culpable period of delay, in that 31-minute period, her mother had arrived by then because she'd called, I think she'd got the flagged down the neighbour's son who had gone and spoken to his mum, who'd called her mother, attended. And by the time her mother arrived, we're at sort of 20 to 4. And in that period, what the defendant's expert was saying, look, claimant's mother was essentially alleviating any distress. And overall, her experience in that period was a feeling of calm and peacefulness rather than anything persuasively distressing. But at trial, Dr. Bowers said in answer to the judge's questions that actually the claimant was always destined to suffer full-blown PTSD from the moment she suffered the subarachnoid hemorrhage, which the judge termed a radical change in the defendant's case. He said, look, on the basis of that, either the PTSD was always going to occur as soon as she had the bleed, or Dr. Smith, the claimant's expert, is right, and we can't determine when it happens in that period, and therefore the material contribution test occurs, or applies, sorry. So applying that back to our timeline, on the basis of Dr. Bowers' evidence on behalf of the defendant at trial, what he was essentially saying is, well, look, at 2 o'clock or thereabouts, when the claimant suffers the subarachnoid hemorrhage, she was always destined to suffer full-blown PTSD. And almost that time between then and when the ambulance arrives is all irrelevant because she was always going to suffer it in any event. The judge said, well, if I don't accept that, then I must accept that Dr. Smith is correct on behalf of the claimant and that we can't determine at what point in that period of time PTSD is triggered and therefore material contribution applies. And so the judge went on to deal with those questions in light of that evidence. And in answering whether, or in addressing whether the court could answer the but-for test affirmatively one way or the other, so those questions 1 and 2 above, the judge said, undoubtedly, prior to the negligent period, so in that 1 hour, 18 minutes of reasonable delay for the ambulance to get there, the period was traumatic. Claimant felt she was going to die. She'd suffered intense physical pain. Nobody could dispute that. But the judge said it does not follow that it's possible to identify a specific cut-off period when PTSD was going to evolve no matter what happened thereafter. At trial, the counsel for the defendant tried his best to cross-examine the claimant on the basis that in that 1 hour, 18 minutes, she'd suffered so much trauma and distress that he could then argue on the back of that, that PTSD was likely to have occurred in that period. Now, how Dr. Bowers stuck to his evidence pre-trial, so his position that it had already occurred before we got to the 31-minute period of negligent delay, perhaps it would have been interesting to see how the judge grappled with that. I don't think it would have made any difference in this case, but it would have been interesting to see his analysis on that point. But what the judge did say is, look, to look at the matter in the way that was suggested by the defendant, to say, actually, in that, at some point in that 1 hour, 18 minutes period of reasonable delay, the claimant had suffered PTSD in any event, and therefore the 31-minute period of negligent delay doesn't matter, is an artificial approach. It's entering the realms of speculation, and therefore isn't helpful to essentially say she suffered sufficient trauma by that time that she was likely to go on to suffer PTSD no matter what happened after that. He said it's impossible to predict on any scientific or mathematical basis, whether prospectively or retrospectively, when a person exposed to trauma is likely to go on to suffer PTSD. If you're likely to apply this in practice to your cases, that is probably a good paragraph from a claimant's perspective to apply, because there have been arguments, perhaps without court decision, on them as to whether you can pick out a particular point in time at which the trauma is so severe that PTSD would have been established or developed anyway by that point in time, and therefore the trauma after that is irrelevant. Judge didn't accept that. He said it's impossible, perhaps in this case, but perhaps more generally, to predict on any scientific or mathematical basis when a person exposed to trauma is likely to go on to suffer PTSD. So we're in the realms, the judge said, of the material contribution test. He dealt with whether the trauma in this case, or the delay made, the 31-minute period of delay made a material contribution quite swiftly. He found, yes, it did. As I said before, it's almost about a third of that period of time in total. And so the claimant got home on causation on that basis. And then the court had to grapple with this second question, which really arises from the case of Hodson, which is a relatively older case comparative to the sort of more recent causation cases, where the judge was asked to consider whether he should conduct an apportionment exercise to essentially say how much of the PTSD is attributable to the 31-minute period of negligent delay. And say, for example, he chose 30%, he would then be asked to apply that to the ultimate loss being claimed by the claimant, and the defendant would only be responsible for paying that amount out in damages. But the judge said no, he didn't find it was appropriate to conduct an apportionment exercise in this case, interestingly, because he went on to say that PTSD was an indivisible injury rather than a divisible injury. And that's important because to conduct an apportionment exercise, you need to be looking at a divisible injury, such as industrial disease cases where you've got noise-induced hearing loss, or asbestosis, where they are dose-related. The more noise you were exposed to, the more dust you were exposed to, the more fibers you're exposed to, they are dose-related. They cumulatively cause you to suffer that harm, and therefore you might be able to divide them up and decide what is the appropriate dose related to the negligence. He distinguished PTSD from those types of cases and said in this case it's not appropriate to conduct an apportionment exercise, and therefore in this case the claimant was entitled to the full loss flowing from the PTSD, which I think was about £40,000. So an interesting case grappling with PTSD and causation generally, which may well be applicable wider in other circumstances dealing with a psychological injury. But that deals with the case of Leach. And then that leaves us with two cases. If I can click us on. Robert, I think we've got a question, if I might, before we just come to you. I'll deal with the question given that it relates to that topic. Cara asks, is PTSD not normally attributable to a certain event or trigger? I think the answer to that is yes and no. I think the answer, certainly not a consultant psychiatrist to be able to answer this question qualified in that way, but my understanding is that PTSD is attributable to a traumatic event. Whether that traumatic event is a single incident in time, or whether the traumatic event is waiting for an ambulance for an hour and 40 minutes whilst you progressively get worse with a severe condition, it really will probably come down to what your certain event or trigger is. The defendant were arguing that it was a certain event or trigger in the context of it was that first hour and 18-minute period. But the judge essentially found, in answer to your question, Cara, that you can't pinpoint one particular moment in that hour and 40 minutes as the event or the trigger. It was the whole period of time that would constitute the event or the trigger for the purposes of developing PTSD. So I think, yes, you are right in general, but an event or a trigger could be a traumatic period of time as a whole, rather than 1 minute or 1 second within that period.
I can see the point that she's making, Marcus, and it seems to me to be one that if you were counsel for the defendant, you could have tried to make quite effectively. Obviously, I don't know the details of all the medical evidence that was given, but I think the inference that can be drawn from that argument is that if you can't show that the negligent delay has made some contribution, then even if the delay is there, the claim would fail. So if you could say that the PTSD must be related to some event in this time, and we don't know which event it was, then you can't necessarily show that the delay has made any contribution to the injury, because the event could have happened in that first period. So I can see the point that she's making, but I also agree with your explanation as to how the judge can get around that by saying it's the totality. Although I have to say my experience of medical evidence is similar, that often psychiatrists will tie PTSD to one particular shocking event rather than necessarily a longer chain.
Yeah, and I think if you change the facts slightly and you said that in that hour and 18 minutes of reasonable delay, as the court called it, she'd called up the ambulance again and had a pretty bad experience with the call hand, or let's say the call handler had said, no, we don't have any ambulances available, and it was that particular point at which she found that particularly traumatic or distressing on hearing that news, then I think you probably could pinpoint it down as that event. If that event was in the reasonable period of time, then I think that would change the facts entirely. I think the court struggled in this case to actually pinpoint a particular event or trigger within the entire period, which is probably why the claimant got home. But I completely agree with you. If there is something you can point to in that period which would bring it before the period of negligent delay, then I think the claimant would struggle in other cases.
And arguably, if you, for the defendant, you might say, well, the burden is on them to prove what the event was, and if you can't prove that the event was at least part in the negligent period, then your claim fails. However, it's an interesting question that was raised. Thanks, Cara, for that. I can see the force of your argument, but I can see how the judge got home here. Marcus, shall I push on to anonymity? Okay. Just briefly, because I know we're a little pushed for time and I want to leave time for any further questions, but I'm just going to whip through a few interesting, or at least I think they're interesting, judgments on anonymity orders, which have come out in the last few months, one a little bit older last year, but they have to draw out some of the fundamental principles of these orders, which we might not come across very often, but which can be quite important in protecting our clients and ensuring we're representing them as best we can in particular circumstances. So the first case is the PQ case that you've got on your screen. Just as a brief summary, the sort of thing that an anonymity order would say. So the order is designed to protect the identity of the claimant and the litigation friend, so they're not disclosed. And normally that prohibition is further defined by words along the lines of there should be no publication in any newspaper or other media, including but not limited to the internet or social media, or other disclosure to the public of any name, address, picture, information tending to identify the claimant or litigation friend as being the claimant or litigation friend in these proceedings. So that is the essence of it. Sometimes there'll be words added to the extent of where there's been a judgment on some contentious issue, words such as save that it shall not be a breach of this order to publish anything contained in the public judgment of this court. So in other words, newspapers can discuss the interesting facts of a judgment, but they mustn't identify the parties concerned. That's the sort of essence of these sort of orders. The first interesting case is this PQ case. And in this case, the judge was required to rule on an application that the identity of a claimant and her family be made anonymous for the purpose of a liability-only clinical negligence trial. And although it's only a short first instance decision, this case really makes the making of anonymity orders in such circumstances pretty likely. It certainly gives the claimants a good argument prior to a liability-only trial where you've got someone who's going to end up going to a settlement hearing if they're a protected party. The facts of the case were that in essence the claimant's care, which was provided by the defendant trust at the time for birth, was negligent, resulted in a severe brain injury and cerebral palsy. As I say, at the start of the liability-only trial, so very late in the day, the claimant made an application for their identity to be anonymised, and the judge noted that in settlement hearings, claimants' identities are normally anonymised as a matter of course, and that has relevance to the justification for his judgment. The case you referred to, you might well be familiar with, the JXMX case, Court of Appeal, and it set out the reasons why at settlement hearings you'll normally get an anonymity order if you ask for it. First is that the court's function in approving settlements is essentially protective and fundamentally different from its normal function of resolving disputes between parties to proceedings. Second, the publication of highly personal information about a claimant's medical condition involves a serious invasion of his and his family's rights to privacy. And thirdly, unlike adult litigants at full capacity who are free to settle their claims in private, the children and protected parties have no choice but to seek the court's approval of their settlements in proceedings open to the public, and thus are placed at a significant disadvantage to other litigants in obtaining respect for their private and family lives, contrary to Article 14 of the European Convention. Now, the first rationale didn't apply prior to our liability-only trial, because the court was being asked to resolve a party's dispute on liability. It's not a necessary step of approving an award. The parties have decided to litigate and go to a hearing. Nor did that third hearing apply. Adult litigants whose claims do not settle are in the same position as protected parties whose claims do not settle. Both must come to court to resolve their claims. However, the second rationale does apply. The liability trial would necessarily involve a serious invasion of the family and its rights to privacy. Mr. Justice Martin Spencer said it was very much a case where the interests of a child and the family under Article 14, I think he meant Article 8, collided with the interests of the press under Article 10. He said it's not correct to view these cases simply as a balancing exercise between privacy on the one hand and freedom of expression on the other. The starting point is the principle of open justice. In other words, that everything should be published unless, and this is the second point, any derogation from that principle must be justified on the grounds of necessity. And in this case, that demand for necessity was met. The justification is interesting. If the claimant was successful and their matter proceeded to a settlement hearing, the case would be anonymised. But if she'd already been identified at the liability stage, then what he termed the jigsaw effect would severely restrict the reporting of the later proceedings, i.e. the settlement proceedings. It was said, Mr. Justice Martin Spencer said, in the interest of open justice, the press should be free to report on settlement proceedings to the fullest ability that they can without trespassing on the rights of the child and the family by identifying the names. In other words, the more strictly the principle of open justice is followed at the liability trial stage, i.e. if he were to deny the application for anonymity, the more severely it would be restricted at the approval stage, because the risk of the jigsaw of identification might mean that the settlement proceedings can't be reported on at all. And in this case, the limited derogation of the principle of open justice in the press not being able to report the claimant's name is more than offset by the correlative ability to report the proceedings from start to finish, including both liability and quantum. So in that case, the order made perversely not to actually protect the rights of the individual necessarily. It was accepted that at the settlement hearing there'd be anonymity. The order was made at this stage to protect the rights of the press, as it were, and ensure consistency throughout, so that the whole of the matter could be reported as fully as possible, albeit with the names out, as it were. So although that case doesn't purport to decide the issue as a matter of general principle, it's hard to see if that decision is correct. The same factors wouldn't lead to anonymisation in most cases of a similar on similar facts. And although the JX-MX case isn't authority for the proposition that approval hearings must always be anonymised, it's clear that they normally will be. So a judge who's dealing with an application to withhold the identity of the claimant at the liability stage will have those same set of basic facts. So absent some special factor, like fraud, for example, it may well be that applications to have the case anonymised will succeed. So it's a useful tool for claimants wishing to do so. Couple of other cases very quickly, and this is on the flip side of things, showing where we haven't got the spectre of the settlement hearing, just how difficult it is to actually obtain these anonymity orders. The first case, Darrell Stewart Jones and the MOD, claimant who was of full capacity, so no settlement hearing, sued for the consequences of a 10-month delay in diagnosing HIV. Trial was to be heard totally remotely. The first morning of trial, once again, the deputy judge receives an application from the Press Association for access to the hearing. Because it's remote, they obviously have to apply to be in on it, as it were. When he informed the parties of his intention to allow that request, he got the anonymity application on behalf of the claimant, and the justification was that he was a private man. He'd kept his HIV status secret from much of his social circle, his employers. He was understandably concerned about the impact that disclosure might have on his relationships with people and his job. And after a certain amount of, some may say, justified grumbling about the timing of the application, the judge nevertheless proceeded to hear and decide it. And he refused that application. He put him in an appendix to his judgment. He accepted that the publication of the HIV status would adversely affect that claimant's private life, but it did not reach the level of gravity that would justify the departure from the open principle of justice. And in his appendix to the case, he said this: "This is not a case, for example, where the impact of disclosure might have a profound impact on the safety of a witness, or where there is evidence that it would have a profound impact on mental health. The agreed evidence of the psychiatrist in this case is that whilst the claimant has suffered psychologically as a result of contracting HIV, his illness has not been very severe, and he's no longer classified as suffering from any diagnosable condition. This is not a case, therefore, where the evidence suggests that the disclosure will cause actual physical or psychiatric harm." That's perhaps an important point. No evidence that it will cause actual physical or psychiatric harm. Relevant to his assessment, again, interestingly, was a finding that the stigma of being HIV positive has reduced over time, which I thought was quite a bold thing for a judge to set out in the judgment. He didn't have any evidence for that assertion. It simply seemed to be his opinion. I suspect the claimant in that case may well have taken a different view. Final case I wanted to look at was the Zeromska Smith and United Lincoln Hospitals, NHS. This was the one at the end of last year. Mr. Justice Martin Spencer again, declining to make an anonymity order in that case again. Negligence of the healthcare defendant led to a stillborn baby, which the claimant had been carrying. Claimant got life-changing psychiatric illness, including some degree of risk of suicide. It was argued on her behalf for the order that publishing her name would risk considerable further harm to the claimant's already precarious mental health and harm her children and family. The judge didn't find that the harm risk, again, was sufficient to make it necessary to make the order. Pretty surprising, some might say, who represent claimants particularly. He ruled that having chosen to bring the proceedings in order to secure damages arising out of that tragedy, the claimant could not avoid the consequences of having made that decision in terms of the principles of open justice and the consequent publicity potentially associated with such proceedings being heard in an open court. And he said, in the present case, the revelation of the matters personal to the claimant and her family are an inherent and intrinsic to a claim of this nature, relating as it does to psychiatric injuries suffered from the stillbirth of her daughter. So essentially what he's saying is that if you choose to bring a claim, which you then take to court, which deals with sensitive matters, including psychiatric history, etc., you have to accept that it's likely that that will then be before the court and that you will be identified. And it appears really again that there has to be some pretty clear evidence of likely harm to result in order for these orders to be granted, where there isn't the spectre of the approval hearing looming. So in summary, those orders will only be made where it's necessary to derogate from the principle of open justice. Necessity, strict necessity, sometimes described as, is a condition precedent. And while we've got these cases with protected parties where it's routine at the settlement hearing, exceptional circumstances will need to be shown before one's granted to a claim with capacity, who's effectively a volunteer in the litigation process. And you've got to prove severe harm, perhaps Article 2 level harm required before one is actually granted. And embarrassment, humiliation, and some degree of societal disapproval, and even some psychiatric injury may not be sufficient, nor is a justified claim to vulnerability enough. So that's the question that we as practitioners, if you act for claimant, should be asking, if you're thinking of applying for such an order, is really, is there any real danger that if the order is not made, the claimant or others would come to serious harm? If you can't show that, you might struggle. Feature of all of these is that the applications are made very late, and it's perhaps obvious to say, but the greater time you give yourself to prepare, collate evidence and present to a court, ideally not on the morning of trial, the better chance you likely have of persuading a judge to make the order. That is the end of my points that I had on anonymity orders. Marcus, I'll turn to you for the mustard judgment.
Thank you. This is the last issue we're going to cover. It's really to note rather than to go into in any depth. If we're in person, I might take a straw poll of hands as to who has dealt with a case where the claimant has covertly recorded the examination with the defendant's legal experts, but over a virtual software platform, a little bit more difficult. These two cases, the case of Mustard and MacDonald, are cases where the courts have very recently grappled with this. The practical point here is it is a watch this space area, because it's developing both in the courts and in guidance outside the courts. Very, very briefly, the case of both cases were RTA cases, so not strictly clinical negligence, but it may well arise in the clinical negligence sphere. Liability not in issue, but both claimants were alleging they'd suffered brain injuries. In Mustard, the claimant covertly recorded her examinations with some of the defendant's experts, but not with her own experts. And those covert recordings included the neuropsychological testing with the defendant's experts. In MacDonald, the claimant actually sought an order from the court to allow him to record the experts' examinations with the defendant's experts, including the neuropsychological testing, but hadn't made recordings of the same with his own experts. So in Mustard, it was post-event. In MacDonald, it was pre-event. But in both cases, neither claimants had done the recordings with their own experts. Courts in Mustard said that covert recordings are not unlawful, and really courts have to balance the relevance and probative value of the evidence versus the public policy interest of excluding it because it had been covertly obtained. But in both cases, particularly in Mustard, the court decided that the recordings as evidence in principle would be considered highly relevant and probative evidence, even if they were obtained covertly. Albeit they recognise that the effect of the claimant's covert recording may have impaired or degraded the results of a neuropsychological test. But they said, look, in terms of deciding on the admissibility of the evidence, this is a marginal fact and it's really a matter to be resolved at trial. And so they didn't really take that into account too much. What they did say was, look, the fact that the claimant's examination with her own experts was not recorded potentially creates an uneven playing field if you've recorded the examinations and the tests with the defendant's experts, albeit in Mustard, the defendant couldn't point to any part of the examinations that a recording would have assisted to resolve. And so on balance, in Mustard, the judge admitted the evidence, but I think that may well be appealed. The case of MacDonald, the court again affirmed that recordings generally would form part of the best evidence available to the court, which they'd want to consider. But they said, look, there needs to be a level playing field. If the claimant's going to record the defendant's expert examinations, they should do that with their own experts as well, so that there's a level playing field. And that applies to all experts, not just neuropsychological experts. But the court held that the defendant's expert should be able to conduct the examination and testing. In MacDonald, the court said because there'd be an inequality of playing field there, it would perhaps skew the case in favour of the claimant's experts over the defendant's experts if the defendant, and prejudice the defendant if they weren't able to pull up issues that occurred in the claimant's examination. The court held that the defendant's expert in this case should have to conduct the examination and testing without it being recorded. And it was argued, or it was held in that case, that if the claimant did go on to covertly record his examination with the defendant's experts, that would, and this was the specific wording of the judgment, that would have serious consequences for his claim. So just worth noting that if you have had claimants who have covertly recorded examinations with the defendant's experts, or are intending to, and that's whether you're a claimant representative or defendant representative, it's worth being wary of these two cases which have litigated this issue in preliminary issues to be decided before ultimately the cases have gone to trial. These cases appear to continue to be litigated, and I think those decisions are going to be appealed or re-argued. And that's within those two cases, within the sort of litigation process. But outside of that, and it's worth noting that the judges in those cases have both made explicit reference to this, that APIL and FOIL, the claimant and defendant bodies, representative bodies in PI cases, are working together apparently to produce guidance which would allow for recordings in certain cases. So watch the progression of those cases to indicate how the courts might deal with it, and watch out for any guidance that's produced by those two organisations for the next time you come across that issue where your claimant decides to stick a recording device on, or your defendant's experts write to you and say, I think that claimant has recorded our examination, worth being aware. Aside from that, we are just slightly, but we waited a few minutes for people to arrive, so we're pretty much bang on an hour, and are more than happy to take any questions via the Q&A chat. If anyone wants to supplement the question that Cara very kindly asked earlier. So give a couple of minutes, but I think, Rob, that probably, given the pandemic and its impact on courts' ability to hear certain cases, it probably rounds up the key or interesting decisions in terms of liability and or breach and causation, and then any other sort of practical tips over the best part of the last 8 or 9 months, really, as far as we're concerned, doesn't it?
Yeah, I think so. I hope so. It's been fairly slim pickings, I think it's fair to say, in terms of really meaty judgments. But I do think I hope the ones we've discussed today are relevant and to our practices and to the law that we'll come and see. So hopefully we'll be of assistance to those watching.
If you do have any questions, we'd be more than happy to answer them. Equally, if it would take a little bit longer to type out and you want to give either of us an email or pick up the phone, then we are more than happy to chat something through with you outside of the webinar. But if there's none coming through, then that just leaves us to say thank you very much for attending. I hope you're having a productive week, and we're on the countdown now to Friday and the weekend. So it leaves me just to say have a good end of the week, and we'll hopefully be able to see you all in person at an event in the new year or soon. So from us, thank you very much and goodbye.
Thanks.